Fix that.
Okay. Hello.
We're Clark is Chipman is supposed to call in. If he doesn't call in the next minute, I'll give him a call.
Okay, great. Thank you. Jordana, I know around 5 or so, nobody had signed up for public comment. Has that changed? You're on mute still.
All right, I just realized that. So I actually just checked and I turned off the form, but I had no one sign up.
Okay, great.
Okay.
Thank you.
Give me just a minute. I'm gonna put myself on mute so that I can, it looks like I have a voicemail and I think it's from Clark. So give me just one moment, okay?
Sure. Thank you.
They've been doing all this board memorabilia since its last meeting. Incredible. I mean, the board memorabilia, I mean, the outstanding value must be $10 billion or something. It's crazy.
Hey, Luke, can we call Clark? Oops, I'm sorry, my video cut out. Can we call him or does he have to call in?
He would have to call in. Does he have all the codes, the meeting ID and the passcode?
He does, but let me walk him through it again, okay? All right.
Okay, sounds good.
Everyone be
Maybe
patient.
maybe he can go on speaker and you can hear him or something.
Yeah, I'll see what I can do. All
Okay,
right.
all right. Thank you.
Okay, Clark is gonna give this another go, so we'll cross our fingers. If not, I'll figure out some way to conference him in, like with the speakerphone or something.
Okay, thank you.
Yeah. I see that someone just joined us, but that's not Clark. Luke, will Clark come up as a phone number?
Yes, that's correct. And I haven't seen any phone numbers tonight.
Okay. Sorry, this is all new to him, so we're just gonna have to be a little patient. Oh, that might be him there.
Mr. Chipman, are you able to hear us? Mr. Chipman, are you able to hear us?
I can.
Okay. All right, this is your Dana, Clark, and I'm gonna turn things over to Carrie Von Hoff to begin, but we're all here right now.
Okay.
All right, thank you, everybody. I'm going to go ahead and call us to order since I was the acting chair for the last meeting. So we are called to order, and to ensure that we have quorum, I'm going to ask the other members of the Board of Ethics to identify themselves. My name is Carrie Von Hoff. I've been the acting chair, and
I'm
Sue
I'm Suzanne Calder.
and
I'm
Clark.
Chipman.
All right, so we have 3 of 3, so it sounds like we have a quorum, and we can go ahead and call the meeting to order since we do in fact have a quorum. The second order of business is to designate an acting chair for the meeting. I am happy to volunteer to continue in that role unless one of my fellows would like to have me pass the gavel to him or her.
I'm fine with you staying.
All right, could I get a motion then to designate me as the acting chair for the meeting?
I make a motion that we keep you in as chair for this evening's meeting.
Thank you. And could I have a second?
Second.
Thank you. I will now take a roll call vote. Ms. Calder
Yes.
and Mr. Chipman.
Yes, I'm here.
And I will, do you vote yes on the motion?
Yes.
And I will vote yes, so the motion will pass, and I will continue in the role as acting chair for the Board of Ethics meeting this evening. The next order of business is to suspend the rules to allow member participation electronically or by telephone, since we are still kind of in the midst of the pandemic and we were not able to have a physical forum for our meeting this evening. So we are going to all participate remotely if we have a motion to suspend those rules to allow that.
I move that we suspend the rules to allow a remote meeting.
I
Thank you.
second the
Can I-
motion.
Thank you. And we'll now do a roll call vote. Ms. Calder,
Yes.
Mr. Chipman,
Yes.
and I vote yes. So we will suspend the rules for the meeting tonight so we can all participate remotely. The next order of business is the approval of the meeting minutes for the July 1st, 2020 meeting. The minutes of the previous meeting were distributed in the packet. And could I have a motion to approve the July 1st, 2020 open session meeting minutes?
I make a motion to approve the minutes of the date you just mentioned.
And could I have a second?
Second?
All those in favor?
Aye.
Aye.
Aye. Aye.
Any opposed? Hearing none, the motion to approve the open session minutes will pass, and we will approve those. The executive session minutes have been distributed to the members of the Board of Ethics. Could I have a motion to approve those executive session minutes?
So move.
So moved.
Okay. Sounds like I have a motion and a second. All those in favor of approving the executive session minutes? Aye.
Aye.
Any opposed? Hearing none, those minutes will also be approved. The next order of business is public comment. My understanding is that nobody has signed up for public comment ahead of time. So we will dispense with this portion of the meeting, but I'll just reiterate that this is a great opportunity to make your voice heard. So definitely avail yourself of this opportunity in future. The next order of business is to go to old business. The first bit of which is ethics complaint 19 BOE 006. The complainant is Mr. Daniel Coyne. Is Mr. Coyne here with us this evening? Yes, I'm seeing him wave and give me a thumbs up. So thank you very much. I appreciate that. The respondent is Alderman Ann Rainey. Alderman Rainey, are you present this evening? And she is waving to me. So the answer is yes. Thank you very much. Just to have it on the record that everybody is present. So thank you. Board members, you've received a draft of the findings and order in this matter from council. And I'll offer the opportunity to discuss this in executive session before we vote on the written findings. But if you don't want that, we don't have to do that either. We can just move to share the ruling and vote.
I move that we share the summary findings and vote.
I agree.
All right, I will provide some context for the finding, which, if approved by the board tonight, will be shared publicly tomorrow morning by the Board of Ethics website. The complaint was filed by Mr. Dan Coyne against Alderman Rainey pursuant to the 2019 Code of Ethics. The board in March did find jurisdiction over this matter, and after a hiatus during the March through June height of COVID-19, we met again on July 1st, 2020 to hold a hearing to consider the allegations against Alderman Rainey. During the hearing, Both Mr. Coyne and Alderman Rainey provided testimony and video and documentary evidence. And on conclusion of that hearing on July 1st, the Board of Ethics deliberated on the pleadings and testimony provided and are now prepared to issue a final finding and order. The complaint alleges, in summary, that Alderman Rainey engaged in prohibited political activities, i.e. campaigning, at the April 1st, 2019 City Rules Committee meeting and at the April 1st, 2019 City Council meeting. The complaint on its face does not allege that comments made at a March 14th, 2019 Ridgeville Park District meeting or a City Council meeting on October 14th, 2019 violated the code. Those were simply background information. And so the board makes no findings with respect to those two, anything said at those two meetings. The code in summary fashion says that no city official will engage in political campaigning on compensated time or use the prestige of the position on behalf of any political party or for any political purposes. Prohibited political activity includes campaigning for any elective office for or against any referendum question. The board evaluated the complaint response, the evidence and exhibits submitted during the July 1st meeting. The board finds that Mr. Coyne is an elected commissioner of the Ridgeville Park District, re-elected on April 2nd, 2019, and that Alderman Rainey is a city councilwoman and constituent of Mr. Coyne. We find that Mr. Coyne was present at the April 1st Rules Committee meeting and City Council meeting, that he read a prepared statement during the public comment section of each meeting. In the prepared statement, Mr. Coyne accused Alderman Rainey of making racist comments at a Ridgeville Park District Commission meeting on March 14th, 2019. The Board of Ethics finds that Alderman Rainey responded to those comments at both the Rules Committee meeting and the City Council meeting on April 1st, 2019. In her comments, she disagreed with Mr. Coyne's characterization of her remarks on March 14th, 2019. She explained that she took issue with the Park District Commissioner's performance and was critical of Mr. Coyne. The board finds that during her statements, Alderman Rainey did not mention any other candidates and made one comment regarding the election the next day. Quote, maybe he got a vote or two. I don't know, but good luck to the good people that are running, bad luck to him, end quote. The board finds that Alderman Rainey's comments at the Rules Committee meeting and the City Council meeting on April 1st, 2019 may have been intemperate and insensitive. However, those comments did not constitute a prohibited political activity or campaign for an elected office. The definition of a campaign for an elected office specifically excludes activities that are otherwise in furtherance of official duties. Mr. Coyne's prepared statement attacked Alderman Rainey's character and integrity, and she was allowed to respond to this attack pursuant to City Council rules. Thus, these statements were made in furtherance of the official duties as alderman. The Board of Ethics finds that Alderman Rainey's comments do not rise to the level of campaigning for an elective office or prohibited political activities. This is an advisory opinion. And I will now ask for a motion to approve the written findings by the board.
I move to accept the findings of the board.
Could I have a second?
I second.
I'll now take a roll call vote. Ms. Calder?
Yes.
Mr. Chipman?
Yes.
I will vote yes. The motion will pass and the findings are adopted. These will be distributed publicly on the Board of Ethics site tomorrow morning. The next order of old business is ethics complaint 19 BOE 007, brought by complainants Ms. Misty Wittenberg and Clerk Devon Reed against the respondent, Mayor Stephen Haggerty. Is Ms. Wittenberg present this evening? I thought I saw her, but she may be on mute. I think I see Ms. Wittenberg. I'm just kind of waiting to hear her verbally say yes.
She's still on mute.
Yes. Mr. Stowe, I don't know if we can unmute unmute Misty Wittenberg.
I've tried to unmute her and for some reason it's not. I'm going to try to ask her to start her video too.
Okay, I'm sorry. While we're waiting for that, I will ask if Clerk Devon Reed is present this evening.
I am present.
Thank you, Clerk Reed. I appreciate it. And again, while we're waiting for Ms. Wittenberg's sound to work, is Mayor Haggerty present this
Mayor
evening?
He is not present. I am here on his behalf, Richard Boykin.
And you were the next person I was going to ask if you were present. So thank you for saving me that question. And are there any other individuals present who are representing any party with respect to this complaint?
No, Ms. Wittenberg and I do not have an attorney.
Okay, thank you. Thank you, Clerk Reed. I appreciate that. And I will
just clarify for the record that we see a screen here that says Misty, and we assume that that's Ms. Wittenberg, but until she responds, I don't want to make that. I don't want to make an assumption.
exactly.
So, yeah, we can just note on the record that she is not, that she did not respond when you asked, and we can move forward at this time.
Okay, Mr. Boykin, we've received your written request for a 30-day continuance until September 2nd, 2020, and I want to give you the opportunity to add anything to your request if you have anything at this time.
Well, Madam Chair and members of the board, thank you very much for having us here tonight. I just was retained a few days ago. I think it's a very important matter before you. And obviously we want to have enough time to present a defense. And the mayor has been busy dealing with the matters of issues of people of Evanston, from racial unrest to gun violence and the pandemic itself. And so we'd appreciate the 30-day extension. Thanks.
Thank Clerk Reed, do you have an objection to the request for an extension?
Well, I do want to note that if I can get maybe Ms. Wysocki, did I pronounce that correctly? Ms. Wysocki, or Ms. Von Hoff, if you can answer this. This case was filed almost a year ago in what, September?
No, the case was, the complaint was filed in November, and I don't remember the exact date. It's
Okay.
Jurisdictional finding, but it was filed at the end of the year, and then the board, as you know, there was a change in the board members, so there was some delay involved in that, and then of course with the pandemic, there's been further delays. So I know that this has been, we're trying to get this done as quickly as possible, but we didn't make or the board did not make a finding as to jurisdiction until July.
Until last, yeah. Until a couple of months ago. I do want to make a few notes here. I personally, I did not receive any notification from the board for the first hearing, the jurisdictional hearing. I do understand, I did, express this to to Attorney Wysocki, and the response that I received was, hey, it was publicly noticed. And so you could have known that the thing was coming in, and I do get that. I happen to be the city clerk. I'm very familiar with the city's website. I can find when the Board of Ethics is meeting. But I do want to note that just because it's not expressly written in the code, I hope that the board ensures that there is a fair process. When it's not the city clerk, I shouldn't receive any special treatment. but also we should make sure that there's a standard of treatment for all residents so they can be aware of when these proceedings are taking place. So I think there should be a standard that we clearly communicate to all parties involved when these hearings are being moved forward and how exactly to get into the Zoom and what the password is. So if that can just be a practice moving forward. To Mr. Boykin's request and Mayor Haggerty's request, this case has been pending since November. The mayor retained legal counsel on the last day that we had to notify the board of whether or not we were going to, who our counsel was going to be. I'm willing to, I am fine with this extension. Of course, everyone should be granted due process to have an attorney. But I would also request that if we're granting this favor, I also believe that our side will need more than 30 minutes to go through the evidence of the case and speak with our witnesses. So if we are going to grant this request for the plaintiff, the defendant, then I would ask that the complainants be given at least 45 minutes and the 10-minute rebuttal for our presenting our case.
If I can respond briefly. I wanted to just clarify that in addition to the, I put my email to you, in addition to the agenda being posted, you received an email a couple, like a week, I can't remember the dates, but I detailed in my email that you did receive notice of the first meeting. I apologize if that was not made more clear to you, but I appreciate the feedback and will, in the future, perhaps make a more formal notice to the complainants as well as respondents. Additionally, I just want to clarify, are you, it sounded like you had no objection to the extension of time to September 2nd. That the mayor has requested, and then you are moving to have additional time in order to make your presentation on September 2nd, correct?
Correct, just 15 additional minutes. So from 30 minutes to 45 minutes with the 10-minute rebuttal after the period for the defendant.
The question I have for you, and maybe you cannot answer this at this time, so it might require follow-up, is the 45 minutes, will that be for both you and Ms. Wittenberg, or will it just be for you?
Oh, so while we did, file this, maybe that's something that we should clarify from the board. We filed this together. So did we each get 30 minutes, or did we get a total 30-minute period? And my assumption was that we got a together 30 minutes to present our case. And so I'm just asking for 45 minutes in total for the both of us. I think I will be the only one presenting at that point.
Oh, okay. That's why I wanted to clarify that if we were talking about, 90 minutes versus 40,
yes.
Obviously makes a difference.
Thank you.
I don't, and obviously this will be up to the board to decide. I don't think that 45 minutes is unreasonable. I also think that whatever time period we give you, though, I think it's only
right. Same thing to both sides. Yeah.
Okay. Well, I'll let the chair make a decision on, or how to handle this if the board wants to grant that at this time, or if they want to talk about it or whatever. But now that we have that clarity, I don't know if you want to continue.
Mr. Boykin, do you have any objection or response to the request for the 45 minutes for the presentation of arguments when the board hears the complaint?
No objection.
Okay. And I don't know if we've gotten Ms. Wittenberg's audio working yet.
I have a question. So what we're proposing is that Reed Wittenberg have 45 minutes to make their presentation, and Haggerty has 45 minutes to make his presentation.
That is my understanding. And then a 10-minute rebuttal at the end, correct?
Okay.
Yeah, and I just want to, Clerk Reed,
Yes.
I don't know if you're on mute, but the
The 10-minute
10-minute rebuttal is
Yeah,
still
yeah,
fine.
for the complainant, yes, at the end.
Okay. Yeah, I think we're looking at 45, 45, 10.
10:10.
I think it's just the one 10-minute rebuttal for the complainants after they've heard
Okay.
the respondent.
Okay. And it's too bad that we don't have Misty on the line, because she's been the person that's been presenting thus far.
I guess I'm kind of taking it from this point. There are a few. We'll get to a few other issues after this, but
Okay.
All right. So I guess we can, and if Ms. Wittenberg is able to, and I'm sorry, I'm going to mute myself for a second.
So I move that the defendant, the people in September, the defendants and the plaintiffs be allowed to make a 45-minute presentation.
Thank you.
I concur.
All right. Sounds like I have a motion and a second. So we'll do a roll call vote. Ms. Calder,
Yes.
Mr. Chipman,
Yes.
I will vote yes. And so that motion will pass, and we will allow for 40. Oh, I'm sorry. You're Dana.
No, finish your sentence, and then we have to roll in the continuance. We didn't have a motion and second for that.
Right. Yeah. Yeah, absolutely. So what has passed and has been discussed is the 45 minutes for each side to present the case in chief, and then a 10-minute rebuttal for the complainants. That will pass on a roll call vote. The second issue is related to continuing the hearing until September 2nd at 7 p.m. And so I'll take a motion for that.
So move.
So moved.
Sounds like I have a motion and a second. So we'll do a roll call vote. Ms. Calder,
Yes.
Mr. Chipman,
Yes.
and I will vote yes. So that motion will also pass, and we will continue the hearing to September 2nd, 2020 at 7 p.m. I'm not 100% sure, but it sounded like, Clerk Reed, you may have had an additional motion, and so we can consider that at this point.
certainly. Thank you very much, Chairman Von Hoff. The next, kind of, I have a few procedural questions before I get to any other motions. So in the leading up to this hearing, there was a request for certain information, for documents, for what we're going to be presenting, and I think we were to turn that in by with 2 days before the hearing. I just want to be clear: does the board want to follow that same schedule, or are we expected to present any exhibits a week out, or what is the procedure there?
I think we did that schedule. That was the same schedule that we used for the coin complaint. That matter. That worked, but it was a little tight for the board members to read everything. So I was kind of, when I set the schedule, I was thinking in terms of IT to make sure they could get things up to the website for the public. But I think that the board would prefer a little more lead time so that they can review the materials and be better prepared for the hearing, so they don't have to, read it afterwards. I don't know if the board members have a preference. A week in advance sounds reasonable to me, but you guys know your schedule better than me.
A week in advance is fine with me.
I think a week in advance is better.
Yeah, I would prefer a week rather than 2 days. I think there's a better chance that I will be fully prepared with 7 days rather than 2.
Okay.
Great, great. I did want, so I don't know if there needs to be a motion on that or what.
I don't know that there needs to be a motion for
Okay,
it.
but we all know. And so that's for both sides. We have to
Yes,
submit within a week. Okay, and then
absolutely. Thank you.
and then once that information is submitted, do I receive the evidence that Mr. Boykin and Mayor Haggerty deliver, as well as vice versa?
So let me make that clear for both parties. So when it is submitted to me, I put it together for the board so that they have it all and it's all, yeah, I take care of it for the board, but also I send it to the IT department at the city, and they post it on the website. Previously, we held off on posting stuff because there was some issues of whether or not exhibits would be entered into evidence and so forth. And I think just for ease of everyone involved, I think we're just gonna put it as all part of the packet. And then if there's, so anything you submit to me, we're gonna put it in the packet, it'll be online. If there's something that you think needs to be redacted for whatever reason, let me know. because I may not have a chance to go through all that, and I'm thinking in terms of, if there's any documents that contain personal information or something that shouldn't be online. But otherwise we'll post it, and then both sides can, go to the website and look it up. So then it'll be disclosed to everyone.
Okay, thank you for that clarification.
No problem.
Ms. Von Hoff, may I continue? So, okay, and then next question of procedure is with witnesses, with calling witnesses at Mr. Coyne's and Alderman Rainey's hearing last month. There, Mr. Coyne called Alderman Rainey as a witness. We are seeking, I am seeking to call Mayor Haggerty as a witness. What is the procedure for compelling testimony? Does this board have a subpoena power, or what are the remedies and options there?
I can answer that. So this board does have subpoena power, but I don't know that it'll be necessary, and that's something that, if you plan on calling the mayor to testify, I don't think I think that's reasonable. That's obviously something that Mr. Boykin may have objections to, or there may be something that he wants limited, and we'll deal with that as it comes up. But unless a witness refuses to testify, there's no reason for us to use the subpoena powers that we have under the ordinance.
Certainly, I just wanted to clarify that it exists. And then, last set of questions, and maybe this is a motion. At the last hearing, like I did mention, I was not, and I know Ms. Wysocki, there's maybe some contention with this fact here, but I was not alerted officially by the board that there was a hearing. There was an email exchange that Ms. Wysocki is mentioning where I believe Misty CC'd me on an email chain that included information about the hearing, but I was not notified by the board of the last hearing. And when it came to the jurisdictional finding that one that Attorney Mason Cup, former Corporation Counsel Mason Cup, is not subject to the ethics code, I have contention in the board's findings. It does not list any reason why she, why the jurisdictional threshold was not met, because she was subject to the code at the time of the alleged offense, and she subsequently left the city. But given that we have subpoena power here, and given that the two barriers are met, are, is the alleged offense covered by the code? One, yes. And then number two, was this person subject to the code at the time of said offense? Yes. I don't see how the answer turned out to be no.
Okay, I think that perhaps this is something that would be better handled in some sort of motion for reconsideration. I understand that you and Ms. Wittenberg, as was evident at the last hearing, disagree with the board's findings on this, but I don't know that the board needs to take a step backwards and go through the jurisdictional findings again. We did that at the at the last hearing.
Well then, Thank you for that. Well, then I will, I guess, make a motion to if that's something I can do, or if that's something the board has to do, but I will request a motion to reconsider, given that the threshold for Attorney Mason Cup under the code is, is the offense, alleged offense, a violation of the ethics code? The answer to that is certainly yes. And then the second jurisdictional threshold question is, was this person subject to the code at the time of the offense? And that's very, very clear in the code. And the answer to that is also yes. Certainly, Ms. Mason Cup, or Attorney Mason Cup could, fight the case however she wants, but as far as the jurisdictional threshold, it has been clearly met under the code.
Just out of curiosity, I guess my first question is a little bit of why does it matter? She's no longer an employee of the city. There's no power that this board has over her as a former employee. The subpoenaing powers of the board have to do with testimony and witnesses. So if you want to call her as a witness, then we can determine if she's willing to participate. But I don't think this board has jurisdiction over a former employee just because the city council doesn't have jurisdiction over a former employee. They can't discipline her. They can't fire her. I mean, what remedy are you seeking?
Yes. Well, thank you for that question. The jurisdiction says, was the person an employee when the offense occurred, and that jurisdictional threshold has been met. There's nothing in the code that says, whether or not, if an employee left. I will note that when we filed this, there was a long delay, but Attorney Mason Cup was still an employee of the city, from my understanding, at the beginning of this process. As far as what remedy do we seek, that question could be said, why would you bring anything against an alderman or an elected official here in the city? Because there really is no discipline or a remedy other than, potential censure, which, really isn't discipline, necessarily. It's just a public disapproval of what happened and a finding of facts, hopefully. And so in the same case here, it's, well, did this employee violate the ethics code while this employee was here? And if they did, this should be if the board finds that this person did, that should be a lesson to all other employees that should not be done here in the city, and it's not acceptable here in our city. Their personnel files, if I committed a crime, in California and I moved to Illinois, the law wouldn't just drop it because I moved away. If I committed a crime or if I committed an offense, then it should be followed to the fullest extent. And like I said, the jurisdictional threshold has been met here. The very clear provision of the code is, was this person subject to the code at the time of the alleged offense? And the answer to that is yes. Now, I will just add one more point that, Attorney Mason Cup could say, well, hey, I'm not an employee there anymore. I'm not going to participate in this hearing. And I guess that would be her right. And then, if we needed testimony, from Ms. Mason Cup, then, potentially the board at that point could grant a subpoena for her testimony if they saw necessary. But nonetheless, the threshold has been met.
Ms. Van Hoff, I don't know if this is something that you want to discuss today. I know that I don't know if this is something you want to discuss today, or if you would like, if the board wants time to consider this, we can take it under advisement with the next meeting. It's up to you guys. If this is something you want to deliberate on now, we can do that. I don't know how fresh the numbers on it.
May I have one more point?
Yeah, sure. Please go ahead.
The one more point is my preference would be, again, since the clear threshold of the code has been met in that case, that the board hopefully makes the decision today to hear the case, if that is the wishes of the board, so we can hear everything on September 2nd at the same time, as opposed to September and then pushing it further back. But I'm open to whatever the board wishes to do.
Yeah, I guess just a couple thoughts / questions. I think maybe for Ms. Wysocki or my fellows on the board. I don't know if we were prepared to rule on a motion to reconsider. It was just not something we had thought about, I think, before the meeting started. Ms. Wysocki, I don't know if it would be appropriate to go into some type of executive session to discuss such a motion, or it could, I mean, one of the things I'm thinking about is if we granted the motion, I mean, we do need to give Ms. Mason Cup, proper notice as well, that we would be expecting to hear from her.
So I guess your question is whether or not we could go into executive session to discuss this. Is that, I just want to make sure.
Well, to deliberate and issue a finding afterward. I don't know if, I mean, I won't speak for anybody else. I don't know if I'm prepared to rule on it. Just, I hadn't given this any thought before we came together today.
I think it would be, just because if you haven't given any thought to it, and now that we've heard the argument from Clerk Reed, I think that it may behoove us to because frankly, even if we were ready, deliberating today, I'd be like reading the stuff at the same time that we were discussing it, because I just haven't looked at this in a month. I would be, unless you guys feel strongly that you want to discuss it today, I would be inclined to hold off, just because I'm not prepared to discuss it, and it sounds like you're not either.
I vote to hold off.
Okay, then and Carrie, this is kind of your thing, but maybe we can have a motion to take that under consideration, or take it under advisement. Clerk Reed's motion.
A motion to reconsider.
Yeah.
And Mr. Reed, just to clarify, are you going to stand on just what you said today, or will you be submitting something in writing?
I can stand on what I said today if I just want to clean up the record just a bit to certainly be able to stand on what I'm saying today. I do want to pull up that specific section of the code that it's 11015. Is that correct, Ms. Wysocki, from your memory?
Yeah, but this is from my memory. Wait.
Yes. Okay. Well,
sorry.
No. You're totally fine. I'm going to kind of
110 something, but I just don't know off the top of my head with the.
If I can find that and then just read that. Okay, I think it's 11014.
I think you're looking at the
new code.
Yeah, so under the old code, it's 110.8D.
Okay, let me find. Do you mind reading that the section that jurisdiction? I apologize. I just don't.
These are the two questions. Is or was the respondent a person subject to this chapter, as defined herein at the time of the alleged ethical misconduct, and is the ethical misconduct complained of covered by this chapter?
Right. Okay. Thank you. Yeah. Thank you, Ms. Wysocki. So just to clean up the record, yes, those that is my argument, that both those standards, those are the only two standards for moving the case forward as far as jurisdiction. Those two standards have been met Certainly, we are alleging offenses that are covered by the code, and certainly, at the time of filing the complaint and at the time of the alleged offenses, Ms. Mason Cup was an employee of the city and subject to the code. So with that clearly on the record, then yes, I do stand on what I said, and of course the evidence that we submitted, to bring forward the case in the first place. And so I will not be submitting any additional written material.
Okay, then is there a motion to,
Could I have a motion to take the motion for reconsideration of the complaint with respect to Ms. Mason Coop under advisement?
So moved.
And could I have a second?
Sue, you're on mute. Sue, can I unmute you?
Sorry.
There.
I'm uncomfortable seconding it, this motion.
Okay.
I'm muted. May I ask, Ms. Calder, what, if that is fine, Ms. Von Hoff, may I ask what you're uncomfortable with or what maybe you need clarification regarding?
My concern is that Ms. Mason Cup is no longer an employee of the city. And what would happen if we move forward with a censure?
Oh, I can maybe answer that. A city employee couldn't be censured. A censure is under the council rules only, and if something that could be given to an alderman, for example.
Okay, so what would happen to Ms. Mason Cup if we found against her?
I maybe Ms. Wysocki can answer that, but I can't answer that. But really what we're considering here is the four corners of the law, which is, did she meet these two criteria to be, to have the case move forward? The answer to that legally is yes. And so, those questions can be answered, Ms. Mason Cup and her attorney, if she so chooses to have one, can answer those questions. Ms. Wysocki can answer those questions. But as far as just moving forward, the true criteria under the law have been met.
Yeah, I think that Ms. Calder's question really is the same question I had, was what's the remedy? What remedy are you seeking?
Well, my understanding of the, I do understand that question. I will just first note before I say what the remedy is. The remedy is, we have an ethics law. It is, we hold, everyone who works for the city to this ethical standard. And, the code says, are you subject to this, were you subject to the code when you committed an alleged offense? If the answer is yes, and the offense is something that is covered by the code, then that person can be heard. The code is silent on, if that person decides to quit because they know an ethics case is coming for, being had, or whatever the case may be. The remedy I'm seeking is to uphold the law here in our city, and there are fines, outside of, what's listed in the code as far as, disciplinary actions, directly to the employee by the city manager or their supervisor. If I'm not, Ms. Wysocki, maybe you can answer this, but the code does also delineate that there's potential financial penalties and fines that could be imposed by this board. So, she could be fined $50 or she could be fined, whatever the case may be. So there is still a potential remedy at play here outside of, disciplinary action as an employee.
Okay, I have to say, I disagree with your interpretation of the code. I know that you keep referring to me, and I just want to make it clear that I don't agree with that interpretation. I think that this is I'm also, well,
I'm sorry, which interpretation?
your interpretation that there's a remedy that's viable against a former employee. I don't interpret that the ethics code in that fashion. And I don't interpret the ethics code as allowing this board to assert jurisdiction over a former employee. But I understand that you disagree with that. I heard you today.
Yes.
I think that Ms. Culler's question about the remedy, I mean, I think that's a legitimate question. I think it's a good question. I don't know if Ms. Culler feels that it was answered to the extent where she is comfortable seconding the motion to take this under advisement, or I guess the alternative is, if we don't take it under advisement, is there a motion then to, the board has to make the motion to reconsider its prior decision. So if the motion to take it under advisement and consider your motion for reconsideration with the opinion to follow, if that died for a lack of second, then I guess the next question is whether or not any of the board members wish to reconsider the jurisdictional findings from July 1st.
May I ask a quick question? Because Ms. Von Hoff, is that fine?
Yes.
Okay. My quick question here is, there is evidence that is being introduced to essentially exonerate Ms. Mason Cup from having to participate in this process. And that evidence is that she is no longer an employee of the city. May I ask, who presented that to the board? Where is that evidence presented to the board that she's no longer an employee? How is that something that the board is aware of for its consideration if there was no, evidence, if that wasn't presented?
So the board is aware of that because I informed them that she was no longer an employee of the city.
So, well, see, I'm a bit uncomfortable with that because, you represent the board, and to present evidence essentially on behalf of Ms. Mason Cup that says, you can't hear this case because she's no longer an employee of the city, and then have that be essentially a deciding factor for why the board doesn't hear it. It to me seems as though you were presenting evidence on behalf of Ms. Mason Cup. And I know that certainly wouldn't be your intention. And I know the board wouldn't want to give off that impression. So if, the board wants to use the fact that Ms. Mason Cup is no longer an employee of the city, I think that the proper way to do that would be for Ms. Mason Cup or her attorney to present that to the board as reason for why the board should not hear the case, but not for Ms. Wysocki to present that to the board. And given that, essentially that whole line of thinking should be stricken, from the board's considerations as that has not been presented to the board in a proper fashion.
Okay.
I would just like to say that I'm not a lawyer, and there's a lot of legalese going along here, but if you want to punish or not punish, but adjudicate against former employees, then I think you need to have a statute or something to do that. I mean, once they're gone, they're gone, and we have to live with their grandeurs and the mistakes.
If I may point the board to, I'm sorry, Ms. Calder, if you were done talking.
I'm done.
Okay, I do want to point the board to past precedent. So for example, Alderman Holmes was an alderman when she committed offense, which was using her city email, I think, to send out campaign solicitations, whatever the case may be. and there was an ethics case brought against her. I believe she was found to have committed that offense, whatever it is. But either way, she was already unseated. She was no longer the alderman of the 5th Ward, and yet the board moved forward with that case against against former alderman at the time, Dolores Holmes. And so, you know, this idea that
what was the outcome of that ruling?
Well, you know, the outcome, I think, I can't tell you the outcome, maybe Ms. Wysocki, if you have that information, but the thing is that the board moved forward with the case based on jurisdiction, because at the time of the offense, Alderman Holmes was Alderman Holmes, but at the time of the case being brought forward, she no longer was alderman. And so she couldn't, you know, maybe be censured, or she couldn't, whatever the case may be. There's certainly no punishment that could be, you know, the term you use, punishment that could be proffered to Alderman Holmes. But there was a clear determination that says, hey, any other alderman or elected official, just know that there has been an ethics determination that you should not use your city email to do, you know, XYZ action, or whatever the case may be, or maybe this was seen as okay. And so now, you know, because this particular instance has been adjudicated, what is and what is not acceptable. And that is what I'm seeking here. Although she formally, although she's not an employee now, she was an employee working for the city, representing the values of the city of Evanston in her conduct. And if that conduct was against the ethics code, I think it's important that, for the record, whether she's an employee or not, it's not about Ms. Mason Cup. It is about the conduct and about having an official record on the city as to whether that conduct is acceptable or not.
Okay.
And I won't speak for anyone else. I mean, Ms. Wysocki may have told me at one point that Ms. Mason Cup was no longer an employee. I don't recall if she did or she didn't. I know I read it in one of the local publications, Patch or Evanston Now or Roundtable or similar. That's how I recall seeing that she had left, because there was an appointment of a new city attorney. So I won't speak for anybody else but myself, but I know I had knowledge of the information.
And Ms. Von Hoff, you are an attorney, correct?
Yes, sir, I am.
And so in your practice and your understanding of the law as an attorney, a judge or a jury, in this sense, you guys are, you know, this is a quasi-judicial board, a judge should not, you know, look to the news or to other, and I'm not criticizing you here, but of course, a judge should not look to the news or other outside sources, anything that is outside of the four corners of the courtroom and what is presented to that judge to make a determination based on the case that is in front of them.
I hear what you're saying. There are some things that are, you know, judges still read the paper, and I mean, I think there are some things that a judge would just take judicial notice of. I mean, frankly, I don't even remember if I was appointed to the Board of Ethics at the time that I read it. So I guess I can't comment whether I was taking judicial or citizenry notice of what I was reading, but I did read it. So
I can interrupt. I think this
Sure.
is a form over substance. Mr. Reed, are you contesting that are you saying that she currently works for the city?
I'm sorry, am I saying who currently works for the city?
Ms. Mason Cope.
No.
Are you contesting that? So, okay, so
Well,
your
Okay.
objection is just that you don't like how the board got the information, you're not contesting the actual information. You're not contesting the fact that she is a former employee of the city.
Well, I'm going to choose not to answer that. You know, we don't, the board essentially, according to the four corners, the board does not know whether she is an employee or not, a current employee or not. There has not been anything presented from her or from any party to this case that would allow the board to know whether or not she is. And if, you know, if anyone read that outside of this, you know, that wasn't presented here, and you shouldn't, you know, I would think it's proper that the board wouldn't be bringing outside information, whether it was gleaned while on the board or before, or directly from you, Ms. Wysocki, the board attorney, which would be, you know, maybe a step worse. they shouldn't be bringing that into the four corners of this particular case,
Okay.
especially as it is a key piece to whether there's jurisdiction here. When that particular question of if she is a former employee or not, I get what your argument is. You're saying, well, she is a former employee, but the four corners of the code simply say, were they subject to the code at the time that the alleged offense was committed? There's nothing about, it specifically says at the time. It doesn't say, are they currently? And the council in their wisdom could have said, are they currently, subject to the code? But no, they specifically say at the time of the offense.
Okay, a couple of things I want to point out, because you do keep referring to this as some sort of court or judge, and I understand why you make.
Quasi-judicial board, is that correct?
No, I don't think it's correct. That's why I want to.
Okay.
That's why I want to clarify. So this isn't a court, and although we are having hearings and we're ensuring that the due process rights of all the participants and parties are protected, this is not a court of law. There's no judge in that sense. There is the board acts as a finder of fact, but the rules of evidence are very relaxed. The ordinance allows them to take in hearsay evidence and take in evidence without the rules are relaxed. It's in the code itself. So this idea that this is, we're trapped in the four corners of your allegations, I don't know that I buy that. And I think that this is nitpicking it into the form over substance and a little getting into the procedure in this way. It's going to be relevant. I understand your argument is she was an employee at the time, and therefore you believe that she's covered by the code. I understand we have a disagreement about that, and the board.
And that's the substance of it. That I just want to make sure that clear that that's not. I'm not nitpicking about how the evidence about her not being an employee. What I'm really saying is that is irrelevant whether she is an employee or not currently. The main thing, and I want to make sure that because you're focusing on the nitpicking, and I want to make sure I'm not coming off. The main thing is the code says, was she subject at the time of the offense? And the whole thing about, how this evidence was introduced is really just pointing to that is irrelevant. So I do agree with you there. This whole thing about whether she is currently an employee or not is irrelevant and it's kind of nitpicking. The big thing is that this board should be determining, and this board and I shouldn't be nitpicking about the thing is, was she subject to the code at the time of the offense? And the answer to that is yes.
Okay. I think at this point we've heard a lot of argument on this, Ms. Von Hoff, I don't know what you want to do at this point. I have in my minutes here that the motion that Mr. Chipman moved to take the motion for reconsideration under advisement. We currently don't have a second on it. If we don't have a second, then it dies for a lack of second.
In a 3-member board, is the chair allowed to second?
Yes.
Ms. Von Hoff?
I think the motion is dying for lack of a second at this point.
Thank you.
So
May I ask one last question? Not to this point. I get that the motion died, so
yes,
I do want to move on. Ms. Wysocki, as far as I understand that this is maybe an administrative board, or it's not of course not a judicial board, but certainly the decisions of this ethics board and this adjudicative quasi-judicial board can be reviewed by the courts, correct?
Through the Administrative Review Act? I would assume so. That's typically how that happens, but it doesn't happen until there's a final decision, and there's no. First of all, I'm not going to get into administrative review law right now, but this is an advisory board, so there's not actually a final decision until the city council reviews it. But
I think the final decision would be that there. So I guess my what I'm just as a citizen, and who's going before a board pro se, with several attorneys. What I do want to understand is that I have recourse with my disagreements on this board finding that Ms. Mason Cup according to the four corners of the law, is not subject to this. My recourse is to have this reviewed by this record, the arguments that were made today, have this reviewed by an administrative court.
So I guess what I'm saying is I'm not in a position to, first of all, I can't advise you on that because I'm not your attorney, but I'm not in a position to tell you how to exhaust whatever remedies you need to exhaust here before the city council, before you can take it to court. There's the Administrative Review Act has there's a lot of steps in it, and I personally am not familiar enough with it to comment on it. I just know that they exist. So I can't advise you. I'm not your attorney, but also I just don't have the requisite knowledge to advise you on what to do to appeal this. That's something you're going to have to do.
Okay, yeah, thank you. I just wanted to understand what my right, not advise me on how to appeal, but just an understanding of my right. Do I have the right to appeal? And my understanding is that yes, courts can review these decisions based on the four corners of the law and based on the testimony that was given by board members and myself. And so I do thank you for taking consideration of this particular item.
At this point, Ms. Wysocki, do we need to do a motion to rule on the motion to reconsider?
Well, if there is a motion to reconsider the July, I don't know if there's a motion to reconsider. The board needs to make the motion. So if there's a motion to reconsider the July 1st findings and jurisdiction, then we need a second and a vote on that. That doesn't mean that it's overturned. It's just a motion to reconsider that, and then there'd have to be a motion on whether or not it would overturn the July 1st. So I don't know if there's a motion to reconsider.
If I can make a final plea for this, I would hope that the board would at least, given that there is maybe some gray area that has been exposed today, that the board would do its due diligence and at least taking the time to reconsider this here at this level before it has to be moved to another level to check the work. I think it'd be great and a show of transparency, especially since this board, we have to remember that the three of you, all fine people and all honorable people were appointed to the board by Mayor Haggerty after this case was filed, particularly to fill the vacancy. Is that not true? You were not appointed by Mayor Haggerty?
No, sir. At least I won't speak for anybody else. Alderman Ravel, in her capacity as Mayor Pro Tem, appointed me to serve. I won't speak for anybody else, but on a temporary basis while these items were pending. Since one of them was against the mayor, my understanding was that he was unable to appoint members. I'm not an expert on that particular portion of the city code, so I can't comment for sure, but that was my understanding when.
My understanding also was that Alderman Revelle appointed me or asked for my agreement to be considered for appointment because she was Alderman Mayor Pro Tem.
And so did you all apply to the board, or were you just hand selected, maybe not by Mayor Haggerty, but you were hand selected, it seems, by an alderman who was Mayor Pro Tem for a meeting to serve on this board? You didn't apply, someone came out and said, hey, Ms. Calder, can you serve? Ms. Von Hoff, can you serve? I'm sorry, Mr. Mitchell, I'm sorry, I don't see your name there, but I think,
Chipman.
Mr. Chipman, can you serve, as opposed to you guys applying and being in a large pool? Is that the understanding?
I had not applied.
Yeah, you were just hand selected by someone, by an alderman who was serving as Mayor Pro Tem to serve in this, for this expiring term, which expires when?
This board was appointed for the limited purpose of hearing 3 complaints.
So, okay, so you're appointed for hearing 3 complaints. You did not apply to the board. You were just hand selected by, some alderman,
like the
by Mayor Pro Tem
I don't, I know what you're implying, and I don't think it's true. I think
Well,
that.
no, I'm not implying anything other than it's true that you did not, that the members here, all fine, honorable people, did not apply to the board, were selected by an alderman, by someone, because they did not apply to hear these three particular cases, which is a case against Alderman Rainey and the two cases against Mayor Haggerty.
Does this have to do with your motion for reconsideration? I'm lost.
Well, I just want to also, well, I guess this might have to do with maybe another motion, but I just want to be clear on the fact that this board was selected for these three cases. No one applied for the board, and you essentially were hand selected to hear these cases only against the mayor and Alderman Rainey.
I think that's something you would have to talk to the alderman who is acting as mayor pro tem. I don't know that any of these board members know why or how or what the selection process looks like. I think that you're going to have to talk to the person who selected them.
Thank you. Thank you. Yeah, I will do that follow-up, but I just guess it is clear for the record that, that the board members were selected, did not apply, but were selected particularly to hear just these three cases, one of them involving the mayor, another involving the former city attorney, and then an alderman. And then, after you hear these three cases, then a permanent board will be appointed. I think that the board should take that into consideration, the perception, and really make sure that given that perception, and given that this is the ethics board, that you want to make sure that, especially when hearing a case against the mayor and the former corporation counsel, that you do your due diligence in hearing whether or not these cases should be brought against these people, especially when the clear four corners of the law say that, this person was an employee and subject to the code at the time of the offense. To bring in another claim that she's not an employee now, which is not written to the code, which is silent in the code, to completely dismiss it.
Mr. Reed, you've made this argument 15 times today. I've heard it several times, and now you're kind of all over the place. There's a motion, or you've made a motion to reconsider. The board can't even get to the point of determining whether or not that's something they want to do because you keep interrupting them. So I understand that you have all these theories, and fine, but that's not really something that we have to answer to you.
I'm sorry, I didn't say any theories. I just stated facts. I didn't say that anyone, I said everyone here is an honorable person. There's no theory. I just said.
Mr. Reed, I need you to quiet down so that the board can get to the things you've asked. We can't get there because you keep talking. Ms. Von Hoff, do we want to, is there any motion to reconsider the July 1st, 2020 findings and order on jurisdiction?
I've not heard one so far.
Okay. All right. Then I'm going to consider that as died for lack of motion. Okay. I don't think there's any other old business, but I'll turn that over to you.
No, I see no other old business. And the next item on the agenda is new business, and there is no new business at this time. So the final part of our agenda is to adjourn. If I have a motion to adjourn until September 2nd, 2020 at 7 p.m.
So moved.
Second?
Thank you. And I'll take a roll call vote. Ms. Calder,
Yes?
Mr. Chipman,
Yes.
and I vote yes. The motion will pass, and we will adjourn until September 2nd, 2020 at 7 p.m. Thank you very much for participating this evening, and have a good evening.
Thank you very much.
Thank you.
Thank you.
Thank you so much.